Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 74. In this podcast we're going to be discussing three cases. The first is an EAT decision looking at whether an employee is under an implied duty to disclose allegations of misconduct to his employer when there's no express contractual obligation on him to do so. Secondly, we've got another EAT case which looks at service provision changes under TUPE, and the key consideration for the EAT was whether a third-party instruction to remove an employee from the provision of services had the effect of reassigning the employee away from the organised grouping for the purposes of TUPE transfer. Thirdly, we have a tribunal decision that looks at whether it was unfair to dismiss an employee who had come to work smelling of alcohol. And finally, as a reward for staying with me to the end of the podcast, I may have mentioned that over this summer I'm doing a number of events, musical or otherwise, and we've had the first of those because I was at Glastonbury last weekend, so a tip from the top for the Glastonbury Festival. So, first case, Basildon Academies and Amadi. This is an EAT case that considered whether an employee was under an express or an implied duty to disclose allegations of misconduct made against him, and whether he was obliged to disclose this to his employer, and whether the employer had acted unfairly in dismissing him when he hadn't made this voluntary disclosure. The case of Bell and Lever Brothers demonstrates that although the duty of fidelity is an implied term in all employees' contracts of employment, and that can include the disclosure of wrongdoing in various circumstances, employees are not under a general duty to disclose their own misconduct to the employer. This, of course, is not the case where an employee has a fiduciary duty to his employer, for example, a senior manager or a director, in which case the employee is then much more likely to be required to disclose to his employer any misconduct. Well, here, the claimant was a tutor at the Basildon Academies. During his employment with Basildon, he accepted a 0-hours contract at Richmond upon Thames College. This was a breach of his Basildon contract, and he failed to notify his employer that he'd taken up employment elsewhere. He was later suspended by Richmond following allegations of sexual assault, although no prosecution ever took place. Basildon was then contacted by the police and informed of the claimant's alleged misconduct. Following a disciplinary hearing, Basildon concluded that the claimant had deliberately failed to disclose both his employment with Richmond and the allegation of misconduct that had occurred whilst he was at Richmond. Basildon concluded that both failures were acts of gross misconduct, and the claimant was then dismissed with immediate effect, following which he brought a claim for unfair dismissal. The Employment Tribunal found the claimant had been unfairly dismissed, but that he had contributed to his dismissal due to his failure to disclose to Basildon his employment with Richmond, and consequently the compensatory award was reduced by 30%. Basildon appealed the finding of unfair dismissal, claiming that although there was no express term in the claimant's contract requiring him to inform Basildon of the sexual assault allegations, there was an implied term obliging him to do so. The EAT disagreed and upheld the tribunal's finding of unfair dismissal. The EAT felt that the starting point was to analyse the terms of the claimant's contract of employment itself. The EAT concluded that all of the claimant's express terms and conditions were set out in a letter which included Basildon's terms and conditions and various policy and procedure documents by reference. The code required the claimant to report any impropriety committed either by himself or another member of staff. But the EAT held that this obligation only extended to an allegation made against him that he knew, or had reason to believe, was true. The EAT therefore agreed with the tribunal that there was no express terms requiring the claimant to disclose the allegations made against him. The EAT therefore went on to consider whether there was an implied contractual term that meant the claimant should have disclosed the allegations that had arisen at Richmond. The EAT acknowledged that previous cases on this were not entirely clear-cut. The starting point in the Bell case had been that there was no implied term requiring you to disclose your own misconduct, and although subsequent cases had indicated it might be possible that an employee would be under an implied duty to disclose his or her own misconduct, there was no case that indicated that there could be an implied term requiring an employee to disclose to his employers allegations, however ill-founded, against him. Such a clause would not be implied, and if the employer wanted the clause, it would be necessary for it to be an express contractual term. Well, the EAT's comments on the express terms of the contract are very fact-specific and so not of general application. It's the EAT's comments on the implied duty to disclose the employee's own wrongdoing, which would have operated to correct shortcomings in the contractual drafting. Well, that's more interesting. I think the clear message from this is that if you wish to have a duty on an employee to disclose any misconduct, you should make it an express term. It's not impossible the court will employ a term requiring disclosure in respect to very clear-cut misconduct, for example. But the implied term is unlikely to help you where the employee genuinely does not believe the allegations of misconduct are correct. The subsidiary and key point here was also that the allegations related to different employment, Basildon versus Richmond on Thames. So, although the allegations related to different employment, and although it was a similar establishment to the employer in question, that was a material factor. And certainly, I think, if you're looking to find that an employee has an obligation to disclose allegations of misconduct to employer B in relation to a job with employer A, I think you would need something expressly agreed term. One further point, as I've mentioned, if the employee had been a fiduciary, it would have been rather easier to show he had a duty to disclose his own misconduct. But as a general rule, the more junior the employee, the less likely it is that the individual will be found to be a fiduciary. So that's the case of the Basildon Academies and Amadi. Next case, Jakowlew, Jakowlew, and Nestor, and Prime Care Services Limited, trading as Saga Care and another. So this is an EAT decision. It concerns a TUPE service provision change and whether an instruction made by the client to the service provider to remove one of its employees from the provision of services had prevented the employee remaining assigned to the TUPE transfer group. Key facts. Well, the claimant was employed as a care worker by Saga Care. He worked principally on a contract for the London Borough of Enfield. Enfield apparently had concerns about the claimant's conduct, so they instructed Saga that, as per their rights under the terms of the service contract with Saga, the claimant should be removed from the group of employees providing services to Enfield. So the customer effectively tells the service provider, remove one of your team. However, Saga wrongly disputed Enfield's contractual right to issue the instructions at the time and took no steps to reassign the claimant. Consequently, the claimant was told that her employment would transfer to Westminster Home Care Limited under TUPE following the expiry of the contract between Saga and Enfield. However, there was some confusion following the transfer of services to Westminster as to whether or not the claimant had transferred with the services, and in the meantime Saga continued to pay the claimant until she was dismissed for redundancy some months later. The claimant asserted that her employment had transferred to Westminster, and so she brought claims of unfair dismissal against Westminster and, I assume as a backup, against Saga. The Employment Tribunal found that the lawful instruction issued by Enfield, the customer, had the effect of removing the claimant from the provision of service immediately. As such, she was not assigned to the undertaking that transferred to Westminster. Well, the claimant appealed this finding on the basis that her employment had transferred to Westminster under TUPE. The EAT upheld her appeal, concluding that it was for Sage as employer and not Enfield as the customer to assign its employees. The EAT held the tribunal had failed to consider whether Sage had actually acted on the instruction given by Enfield. Although the EAT recognised the instruction given by Enfield was indeed a lawful instruction, Saga had disputed this at the time and so not acted on it. The EAT concluded that although the contract between Saga and Enfield enabled Enfield to give such an instruction to Saga, it did not, however, quote, authorise Enfield to assign an employee itself. It was for Saga to decide what action to take. It could have taken steps immediately to remove the claimant from the group of workers dealing with the contract. If so, she would no longer have been assigned to the group, because the employer would no longer have required her to work in that group if her absence had not been excused at the time. Unquote. Well, the EAT was referred to and considered closely an earlier case called Robert Sage Limited and O'Connell. Well, in that case, the employer had taken steps to remove the employee from the provision of services to the client, following an instruction from the client to do so. The EAT considered that, in such circumstances as the Robert Sage case, an employer may be considered to have changed the assignment of an employee from the group of workers concerned. However, Saga here did not take that course of action, and consequently the EAT held that it doesn't follow that the unilateral instruction of a third party causes the employee to cease to be assigned to the organised grouping of employees at that point. I mentioned this case as the issue of whether or not an employee is assigned to an organised grouping of employees is a common question in the world of TUPE. Often, customers have views on the transferor's employees, and this can be a difficult question to navigate, both commercially and legally. This case provides useful guidance on the topic of assignment and demonstrates it's the decisions of the employer and not the client that are key to determine whether an employee is assigned to an organised grouping of employees. I think, with respect to the EET, the decision is an entirely sensible one. It would be a very odd set of circumstances if the customer's decision automatically meant the employee was no longer assigned to the relevant grouping. Therefore, if faced with a similar situation, the customer should ensure that the employer has acted on its instructions ahead of the transfer if it's issued instructions to remove an individual from the providing services. And it's possible that if the employer failed to act on the lawful instructions of the customer, the employer might be liable in damages for breach of contract if the employee, who shouldn't have transferred, then transfers across under TUPE. It'd then be a case of deciding who was liable for the necessary damages. Anyway, so that's the case of Jacolo, however you pronounce it, and Nestor Prime Care Services Limited. Third and final case, it's a bit of an oddity. It's a tribunal case, an employment tribunal case. And it's McElroy and Cambridgeshire Community Services NHS Trust. Well, this is an employment tribunal case which considers whether an employee who turned up to work smelling of alcohol was unfairly dismissed. And I think the reason, just to say up front, the reason I wanted to include it, there's no great principle of law in this, but it's a really good illustration of the need to consider the facts, consider whether the test for a fair dismissal has been met, rather than making assumptions. So, by way of brief reminder, in misconduct cases, a dismissal is fair if the employer believes that the employee is guilty of the misconduct, the employer has reasonable grounds for that belief, and the employer carried out as much investigation as was reasonable in the circumstances. Well, in this case, the claimant, Mr. McElroy, he was a healthcare assistant at the Cambridgeshire Community Services NHS Trust. His colleague told his manager that he thought Mr. McElroy smelt of alcohol at work. The manager interviewed the claimant and came to the same conclusion. When questioned, the claimant said that the reason for this was because he'd drunk a couple of beers the night before. He was subsequently suspended pending an investigation under the Trust disciplinary policy, under which it considered gross misconduct for an employee to be unfit for duty through the effect of drink. During the investigation, it came to light there had been other occasions where the claimant had come to work smelling of alcohol. When asked, the claimant gave various inconsistent responses, quote-unquote, about the reason for the alcohol smell, including it was aftershave, garlic, or alcoholic gel. However, there never had actually been any concerns raised about the claimant's behaviour or any concerns that he'd actually been drunk at work. Furthermore, an occupational health report, which was based solely on information provided by the claimant, concluded he was fit to return to work, and any further concerns should be dealt with under the substance misuse policy. At the time of the investigation, the claimant had been admitted to hospital for a disease which was associated with excessive alcohol consumption. As such, the investigator felt that the disciplinary hearing should be postponed until the claimant attended a further occupational health appointment. The claimant failed to attend this second appointment, and he made it clear he was not prepared to attend any further OH appointments. Well, the employer ultimately dismissed him for gross misconduct, and this was on the grounds that he'd attended work under the influence of alcohol and had failed to follow reasonable management instructions in not attending the second occupational health appointment. The tribunal acknowledged the Trust had been reasonable in its findings that the claimant had attended work smelling of alcohol, and it was unlikely to have been 2 cans of beer the night before. Also, the Trust had been reasonable in seeking a second report from occupational health in the circumstances. However, and maybe surprisingly given the facts of the cases mentioned, the tribunal found the claimant had been unfairly dismissed, and the judge concluded that a reasonable employer would not have treated the claimant's acts as amounted to a gross misconduct in the circumstances. This was primarily because there was no evidence of any negative impact on the claimant's ability to do his job, and nor had there been any previous warnings given to him. One other significant factor in favour of the claimant was that the Trust had not told them their failure to attend the occupational health appointment was being considered a disciplinary issue, and therefore it was unfair to use that as a reason when deciding whether to dismiss. In addition, the judge found that under the Trust policies, a reasonable employer would not have treated a refusal to attend an occupational health appointment as an act of gross misconduct. So, the question is, what should an employer do if such a situation arises? Oh, well, may you ask. With the benefit of hindsight, and of course we have to be very careful when looking at cases, what's clear after a case may not have been clear at all in the run into the case. Here, the key failures seem to have related to the disciplinary itself. In essence, the Trust jumped a couple of key steps. It didn't issue a first warning to the claimant for coming to work smelling of alcohol, and it didn't make it clear that any failure to attend the second occupational health meeting was going to be considered a disciplinary issue. Nevertheless, I think the outcome of the case is still somewhat surprising. You have an employee who turns up for work on more than one occasion smelling of alcohol, gives various differing explanations, is then admitted to hospital for a disease associated with alcohol abuse, and then refuses to attend an occupational health appointment. However, it's clear that the main point for employers to take away from this case is the importance of having clear policies that set out what is and what is not acceptable behaviour in the workplace. In addition, there's a need to follow a careful disciplinary process and keep the process under review. It also highlights the importance of drawing each conduct issue clearly to the employee's attention, whether these are initial disciplinary proceedings or charges which arise during the course of the disciplinary process itself. It's then necessary to give the employee the opportunity to respond to those charges. In this case, had the failure to attend the occupational health doctor been identified clearly as a disciplinary issue, and had the client received a warning for his refusal, a dismissal further down the line would have been rather easier to justify. Obviously, it's much easier to point out omissions in a disciplinary procedure with the benefit of hindsight. But this is a useful reminder to all employers that even in relation to what looks like a straightforward dismissal case, it's essential that a comprehensive disciplinary procedure is followed and reviewed. So that's the case of McElroy and Cambridgeshire Community Services NHS Trust. Just a quick reminder, the podcast is available from the Mayor Brown intranet, from iTunes and from YouTube. The YouTube version has the case names scrolling across the screen while we're talking about them. It's also available. I post links on Twitter, Nicholas Robertson at Nicholas ROBER, and then the number 1 and the number 1, so Nicholas Robert 11. So, I said I'd say just a few words about last weekend and my trip to Glastonbury in the company of a very, very senior employment QC, and I spent some time talking to a friend of mine who's an employment tribunal judge, and yes, I confess there were occasions we talked about employment law at Glastonbury. How sad is that? Anyway, the highlight, there were lots of highlights. It was a really cracking festival. But I suspect the highlight was my friend and I, we went along to see Patti Smith on the off chance, not knowing much about her. But halfway through, we were talking, saying it was really good. And then she brings out the Dalai Lama, and we all sing happy birthday to him, which counts as one of the more surreal experiences in my life. And at the end of it all, in tribute to the Who are the closing act, she plays the most stellar version of My Generation, which truly had to be seen to be believed. So, yes, so there's my tip. So she's touring later on this autumn, and I'm seriously considering buying tickets to go and see her properly, because she was absolutely magic. So there we go. Law and music recommendations from Glastonbury. What more could you ask for? So thanks very much indeed for listening, and until we speak again next time. Take care.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.